requested 30 minutes. Did you wish to reserve any of that 30 minutes for rebuttal?
Yes, we'd like to reserve at least 10 minutes, please.
Very well. We'll go ahead and try to keep track of that for you. At this time, you may begin your argument.
Thank you, Your Honor, and may it please the Court. The California legislature has enacted the anti-SLAPP statute to provide victims of SLAPP suits with a ready, expeditious means to quickly dispose of those suits and to recover the fees and costs incurred in having to do so. This case involves a prototypical SLAPP situation. Mario Delis sued his former business partner for claims related to their partnership, and then Mr. Thorn responded by filing a prototypical SLAPP claims in a cross-claim. Accordingly, Mr. Delis moved to strike these counterclaims, whose basis was essentially that Mr. Delis had sued Mr. Thorn, so he's suing him back. That motion was successful, and the framework created for the situation by the California legislature makes it such that the claims are, once stricken, are permanently barred with no opportunity to replead. We're here today because the trial court awarded Mr. Delis only 18% of the fees requested, and that award included no costs when you look at the court's math. And I'd like to, I'll note that this is a matter of discretion. This appeal raises purely legal issues, and the abuse of discretion standard, as stated in a number of cases like before the court too, applies when the court follows the law and works within the legal framework set forth by the Supreme Court of California and the Courts of Appeals. But those legal rules are the confines of the discretion, and whether they're transgressed is a question of law.
Did you wish to address the question of whether the order is appealable?
Yeah, sure. I can briefly speak to that before I give a roadmap on the substance. So, as for appealability, this is an appealable collateral order from a final order disposing of the anti-SLAPP motion. We think it's clearly a collateral order because it requires the payment of money, and it is entirely unrelated to the ongoing claims in the underlying litigation, because the nature of the stricken claims was that they were based on Mr. Delis' filing a lawsuit, not based on any of the same facts or circumstances as the underlying claims. And I think it's particularly important that it was an award requiring a party to pay money, and there were no further proceedings to be had on that issue. The dispositive case, as we see it on appealability, is the City of Colton v. Singletary case, which also addresses appealability of an anti-SLAPP fee award. I'll also note that that analysis, in addition to being correct on the law as we see it, does dovetail with the purposes and liberal construction of the anti-SLAPP statute and the fee provision, because the whole idea of the fee provision and that remedy is to quickly to mitigate the chilling effect on the petitioning activity by quickly providing the victim an opportunity to transfer to the party who filed the wrongful suit the costs of having to respond to that suit. So requiring a litigant, basically a cross-defendant, to have to wait potentially years before grouping it in with merits appeals related to the underlying lawsuit would thwart the policies of the statute by allowing the strategic gambit to create a financial disadvantage for the cross-defendant. Turning to the substance of the appeal, I'd like to just mention a couple different items as a roadmap, and then I'll go into them in more depth. We believe that reversal is required in this case because the way the court arrived at the decision to award only 18% of the fee requests included departures from the Supreme Court's framework for determining anti-SLAPP fee awards and legal rules set forth by the Courts of Appeal. First, the court stated in its order that, or clearly implied in its order, that it had penalized Mr. Delis for not waiving his rights and for insisting on pursuing his anti-SLAPP motion, which was a meritorious motion, and he obtained the relief requested just as the legislature gave him every right to do. Mr. The opposing counsel, Mr. Thorn, wanted Mr. Delis to waive his statutory rights, never made any kind of offer to give him the same relief. In fact, specifically said that he wanted to be able to replead, which would, as stated in one of the cases we'll look at, would give him a ready means of escape to people who file SLAPP suits. So Mr. Delis had every right to insist to move forward with his meritorious motion, and he did so. The court was erred in penalizing him for that. Second, the second way the court erred is that the trial court's order makes clear that it didn't compensate Mr. Delis for anything beyond the initial SLAPP motion itself, plus another $3,200 tacked on to a fee motion. But ultimately, because of the vigorous opposition mounted to both the SLAPP motion and the fee motion, Mr. Delis, his attorneys, ultimately had to file 11 research and draft 11 substantive filings, and argue at 3 hearings, 3 substantive hearings, all not counting this appeal. And so under this anti-SLAPP statute, it's a mandatory fee award, it's not discretionary. He was entitled to recover for those. Then finally, the court didn't apply the appropriate lodestar analysis as required by precedent. And it didn't do so in at least 4 ways. First, the court did not begin its analysis with the number of hours actually spent on the case as provided in the attorney declaration. It's not that the court started there and then made adjustments, the court just didn't use it at all. And that declaration was entitled to a presumption of accuracy, and no deficiencies with any of its entries were identified. Second, the court selected an arbitrary lodestar rate lacking any support in the record or elsewhere that the court pointed to. Both parties, the respondent did not challenge the requested lodestar rates, which included a partner rate of $550 an hour and an associate rate of $385. We submitted unrebutted evidence that those were appropriate for the forum market of Kern County, and those were below market for the attorney's home market of Los Angeles. Third, the court improperly penalized Mr. Delis, or at least referred to it in his opinion, on this issue of apportionment between stricken and unstricken claims, and improperly says the basis for reducing the award was the survival of a declaratory relief claim that was redundant and purely derivative of the stricken claims. Because those are from the same set of facts, that claim arose from the same set of facts, apportionment is not proper in that instance. Finally, the court did not do any kind of multiplier analysis as required by Ketchum. When the Supreme Court of California provides a legal test for the court to apply to determine whether a request should be granted or denied, it's an abuse of discretion to fail to perform that analysis, and the court didn't. With that said, I'll move into to the first point. So the first point is the theme of the court's decision, as reflected in the transcript from the 6/29 hearing, is this implication that Mr. Delis should have compromised or waived his rights under the anti-SLAPP statute upon the request of the defendants. First, there's a mischaracterization of the actual record, and the actual correspondence between the parties can be found in the appendix between Appendix 290 on through Appendix 300. But I point the court in particular to Appendix 298, where Respondent's counsel clearly says that they believe they should be allowed to replead, which is directly contrary to the policies and effect of the anti-SLAPP statute. And Mr. Delis was not required to agree to that, nor under precedent was he required to agree to anything short of what the legislature offered him if he were to succeed in his motion. Nevertheless, Mr. Delis' counsel still offered for a stipulated resolution, giving Mr. Delis approximately the same relief, and Mr. Thorn's counsel rejected it, and by filing a opposition rather than following up or saying, yes, we can do that. So why Mr. Delis was penalized for doing what the legislature allows him to do, I don't understand, but I do know that it is contrary to precedent. It's been dealt with several times, especially in the context of Consumer Legal Remedies Act claims. I point the court in particular to the case of Goglin v. BMW, 4th Cadillac 5th, at 472, and McKenzie v. Ford, 238 Cal at 4th, 695. And in both cases, the court said, well, you didn't offer exactly what the statute allows, and then they just chose to sue anyway. That's not what happened. In both cases, what was being offered or discussed, it included extra terms or less sufficient terms. And there's no requirement to compromise your statutory rights, and those are not bases to cut a fee award. And those cases are directly on point as we see it. Additionally, there are instances of the broader principle that trial courts may not reduce a fee award due to factors not required by the statute. The court's required to, these are mandatory, not discretionary fee awards. We cite the case of Graciano v. Robinson Ford Sales, 144 Cal at 4th at 153. And the Graciano case makes clear that the trial court's preference for compromise or the trial court's sense of the equities just don't factor into the analysis. Next, the court's opinion says that it didn't compensate Mr. Delis, or suggests that it didn't compensate Mr. Delis for work after the initial anti-SLAPP motion. And I point the court in particular to the language in the transcript's tentative, also in the minute order, referring to the amount claimed after filing the initial anti-SLAPP motion. To the extent the court based its award on just the fees for the initial motion, and basically allowed Mr. Thorn to have a free shot at resisting the motion, that's been held to be in abuse of discretion, inherently in abuse of discretion in the Roe v. Halpig case, because it would be because that's the fee award here is mandatory; it's not discretionary, and that's the Roe v. Halpig case at I'll give you a citation. It's at 312, 29 Cal at 5th at 311 and 312. That case also is notable because it makes clear that the basis of the calculation must be the actual hours devoted to the case as a starting point of the analysis. And that general rule comes up a number of times. Third, I'll note the court's departures from the lodestar analysis. I already mentioned above that if you review the court's math as stated in the tentative opinion, which the transcript itself is the order appealed from here, because we requested a written ruling, and the court said no, the transcript will be the ruling. I point the court to that in the 628 transcript. I believe it's on page 7. So the court did, when the court's math is reviewed, the court didn't factor in or award costs. And secondly, the court did not begin its analysis with the attorney's declaration, meaning the court didn't start the lodestar analysis as it was required to by reviewing the time actually spent on the case. This is not a situation where the court looked at that and then made adjustments based on, because it found this time over that time, the court identified no problems with the declaration and no specific deficiencies whatsoever. And despite that, it didn't even factor into the court's analysis. It's clear from the transcript and the minute order that the number of hours set forth in the declaration just was neither the starting point nor otherwise a consideration. And I would note, I'd point the court in terms of precedent on that one to in particular the Roe v. Halpig case that I cited previously, 29 Cal at 5th, 256, the court must begin its analysis by looking at the total number of hours counsel actually spent. Sure, it can adjust from there, but it has to begin there, and the court did not do so here. Next, the court selected, so having selected an arbitrary number of hours untethered to the number actually spent, the court also selected an arbitrary rate that lacked any support in the record. As I noted, the rates requested were supported were thoroughly supported, and they were not contested by the respondent. Indeed, they submitted purported expert testimony, basically adopting or applying the same partner rate of $5.50 an hour. So there was no evidence in the record to select any other rates than those offered by the appellant. The trial court simply selected a $400 an hour rate, but provided no explanation or basis for that decision, even though no party argued for that number. Again, on the issue, continuing on point number 4, as to how the court didn't apply the lodestar method, the court improperly analyzed the apportionment issue. The cases are very clear on this one that claims, a fee award can only be reduced for uncertain claims if they are based on a different set of facts, or and completely different legal theories. And that was not the case here. The surviving declaratory relief claim had no damages associated with it. Mr. Delis sought out to strike $15 million in cross claims, and that's exactly what his motion accomplished. And the declaratory relief claim was not based on any kind of separate allegations or separate set of facts. It was the same. It was entirely derivative of the other claims. It simply said that these contracts referred to in the other claims form a unified set of contracts, basically. So the apportionment was not appropriate in that instance and cannot be a basis for the reduction, insofar as it was one. And then finally, the last point in which the court did not follow the lodestar method as set forth by precedent is that it didn't undertake the appropriate, the required multiplier analysis. We offered a detailed briefing on similar cases in which multipliers have been granted. We noted that we were on a highway contingency arrangement with Mr. Delis, which is precisely the circumstance identified in the Ketchum v. Moses extensive discussion of multipliers. And the Supreme Court, in the Ketchum case, sets forth the factors that are to be considered. And there's a number of cases making clear that when the court, when a court doesn't analyze an issue using the legal framework supplied by a statute or by a higher court, that amounts to, sometimes it's called a failure to exercise discretion. It's inherently an abuse of discretion. And I point the court on that point to the case of Dixon. That's 83 Calap 4th at 449. So whether or not we would be entitled to the multiplier may be another question. However, that was never analyzed in the first instance, so far as we can tell from the court's ruling. I believe that the appellant is entitled, along with the other relief we're requesting, to a considered order that analyzes the factors under the appropriate test. With that, unless there are questions, I will reserve my time for rebuttal.
Thank you very much. There do not appear to be any questions. You have about 12 and a half minutes left. We'll hear from respondent. Thank you. Mr. McCarl.
First thing we need to clear up here is that, unfortunately, counsel's misrepresenting the record in a number of respects, starting with the ruling. So, first of all, the counsel's conflating the initial preliminary fee hearing ruling at April 13th, 2022, with the later one, and attributing supposed findings that the court orally made on April 13th to the order that's on appeal. That's not the case. The court said in that initial hearing, can you please submit a new declaration breaking down hours by time? The court also made clear you do not need to submit time records, and that is supported by the law. We didn't need to, and the court specifically said we didn't have to. So I point the court to the April 13th transcript.
Mr. McCarl, if that's the case, then why did the court call for you to file additional time records or other evidence, or did they? I mean, what was the point of the supplemental declaration?
The court did ask for that additional information, but we supplied it. So what's at issue here is the later supplemental fee declaration that the court considered. That's the only fee declaration that matters to this appeal. So Mr. Lynch, by conflating the actual ruling on appeal with the earlier request for an additional briefing, is misleading. But more importantly, looking to the actual June 28th hearing, This is, I mean, it's a complete misrepresentation of the record to say that the court said there was anything wrong with the declarations. In fact, the court identified no specific problems with the declarations, nor did the court make any sort of finding about credibility. I point the court, and let's be clear, this, on page 7 of the transcript, we asked for a written ruling, the court said, no, this oral ruling, this transcript is the ruling. And so that's what we have to go on. Now, I was surprised to hear in the hearing when I argued it, the court's tentative statement about credibility and about padding, because it seemed to me that we had given the court exactly what it requested, which was to simply take what the attorneys, the different attorneys, state their billing rates and state how many hours they worked on different sections of the motion, and that's what we gave the court. So I asked the court if it could clarify what it meant and identify what problems it saw in the declaration, and I went to court to page 11 of the transcript. The trial court said, you characterized my comments holding your declaration to be deficient. I didn't say anything in that regard. And on the next page, on page 12, the court said, disregard what I said. In other words, the court initially said that in a tentative, but when asked for specifics or clarification, the court said, forget I said it. Therefore, it's not part of the record. And, you know, it seems to be the entire basis, the large portion of the basis of the opposition. And it's just a misreading of the record. Similarly, the court, unfortunately, the respondent is also misrepresenting the record of negotiations. It is very, I heard the phrase stated that we got everything that we were offered. That's not the case. I pointed the court to the applicable, the relevant correspondence between the parties, and once again, I'll just note that that the AA 298 clearly opposing counsel. First of all, they never offered to pay any fees. They never offered to dismiss all the claims of prejudice. And in fact, on AA 298, Mr. Lynch said we need to have the ability to replead. Mr. Delis has the right, given by the legislature, to stop that from happening, and we have a duty as attorneys to vindicate that right. Should he choose to pursue it. And the motion succeeded, meaning it was non-frivolous. It was in fact correct. And the precedent's very clear that a trial court's preference for compromise or discretionary consideration of equities plays no role in awarding fees under the mandatory statute. These are not purely discretionary. They're mandatory under the statute. And I'd also note that it's not just the amount. The court can pull out of the air a number and determine reasonableness in the abstract. The court has to follow the formula provided by the appellate courts. The Supreme Court of California and the appellate courts have provided a methodology that courts are required to follow to ensure that these awards are non-arbitrary. That begins by looking at the number of hours reasonably spent. And if there's any specific deficiencies or duplicative work or something, the court sometimes identifies those and backs them out. But again, that's not the process that was followed here. The declarations of the attorney were not considered at all in the analysis. So it's really about how the court reached the conclusion, and that is not a matter of abuse of discretion. Whether the legal rules applied were the correct ones is reviewed de novo. Not if the court had acted within the framework of those rules, then it would be abuse of discretion. But the arguments that we've made, we've explained to the court a number of ways in which the trial court just didn't apply those rules, and what it did do goes directly contrary to precedent insofar as it was penalizing Mr. Delis for insisting on his statutory rights, and insofar as it was disregarding the attorney declarations and disregarding the lodestar rate and selecting arbitrary numbers of hours and multiplying by an arbitrary rate. And then finally, the last thing I'll note, unless there are the last point that I'll note for rebuttal briefly is this argument that about there being no prejudice in the appeal. This is truly a case where justice delayed is justice denied, because the whole purpose of the strategic attack on the plaintiff appellant's petitioning activity is to magnify a financial advantage. And that's why the anti-SLAPP statute exists and is liberally construed to prevent such strategic use of the courts to acquire advantages through illegitimate means such as filing or frivolous SLAPP counterclaims. Mr. Delis ought to be compensated, as the legislature intended, within a reasonable time frame of that award being finalized. It's a collateral order, so it's not when the respondent argues that there's no statutory or case law support for it. It's just not the case. It's a collateral order. It fits squarely within the collateral order exception. His primary case that the council relies on, Doe v. Lester, it actually was not the same situation at all, because in that case, the opposite side prevailed. So, in other words, it's Doe v. Lester, 145 Cadillac Wharf at 142. The order was declining to award attorney fees to a plaintiff who successfully opposed the motion to strike, meaning the litigation continued. So that's not the situation here. The motion to strike targeted the claims at issue in the litigation, and the motion was denied, therefore those claims continued. That's not the situation in this case. In this case, the counterclaims were unrelated to the challenge counterclaims were unrelated to the merits of the underlying litigation because they were based on the act of suing. And that issue has been fully disposed of. The rent portion of the first cause of action that Mr. Lynch alludes to, again, that's a misreading of the record. First of all, the respondents dismissed that claim. Second of all, it wasn't challenged in the anti-SLAPP motion. The challenge cause of action arose directly from the petitioning activity with no alternative basis for it, because under the Barrel case, the Barrel v. Dick case, we only challenged a portion of the rent cause of action, and that portion was insofar as it arose from the litigation privilege activity of filing a lawsuit. I will also, I think that I'd also note that the complexity of this litigation and the fact we're looking at a long time until there's an appeal on the merits, and it's going to involve a whole lot of issues. All this is, as we can see from the volume of briefing, is its own complex issue that is entirely severable and different from the underlying litigation, and it does not make sense to group it. It's not efficient to make the parties wait for years and allow Mr. Thorn in the meantime to have deferred the cost of his SLAPP suit onto the plaintiff appellate.
Now, counsel, I have a question for you. Is it efficient to burden the courts with several different appeals on these various issues in your lawsuit? What about judicial economy, I guess is my question.
I think that separating completely severable issues is the purpose of the collateral order doctrine. So that's the policy choice that the state has made. And I agree with it. This fits within the collateral order exception because it involves the payment of money, and it is a finally terminated issue in the litigation. I'll also note that the respondents did appeal the anti-SLAPP order, and then they dismissed the appeal. Their theory would allow the appellee to control when the award can be appealed, because then they can decide to notice the appeal initially and then pull it back because they don't want to actually go have that appeal anymore. That can't be the rule, and it would be at odds with the anti-SLAPP statute. I want to close on this note, unless there are other questions. The anti-SLAPP statute is to be liberally construed along with this fee provision. Pursuing anti-SLAPP motions and pursuing fees as a result vindicates the public policies of the state of California as expressed in the statute and as reaffirmed by the courts. Mr. Delis did the right thing by vindicating his own rights under the statute, and it was Mr. Thorn's choice to file the SLAPP claims in the first place and then vigorously oppose the motion and fee motion that created all the hullabaloo that has followed. But as the Supreme Court of California stated in the Serrano case, a litigant cannot litigate tenaciously and then complain about the hours necessarily spent in response. And the fact that because of that opposition and because of their decision to file the claims and their refusal to dismiss them, even after they knew the motion was meritorious, Mr. Delis, to vindicate his statutory rights, which he ultimately succeeded in doing, except for the past of the fees, we had to file 11 merits briefs, 11 merits filings, and 3 hearings. That's expensive. And so for the court to arbitrarily select a list array, arbitrarily select a number of hours, and then somehow blame Mr. Delis for Mr. Thorn's decision to oppose the meritorious SLAPP motion and then the meritorious fee motion. It just doesn't make sense, and it thwarts the purpose of the statute. Ultimately, what the trial court has given here is it's given Mr. Thorn exactly the strategic advantage that he sought when he filed that strategic lawsuit against public participation. Mr. Thorn is the sole person responsible for the costs flowing out of that decision and from his own decision to continue fighting it. He had every right to fight it, but he was also responsible for the costs at the end of the process. And so we would strongly urge the court to find that this is a collateral order, it's properly on appeal, and it should be decided now. The court should reissue a new order in accordance with the rules that I've set forth, as set forth by the courts of appeal. Thank you.
All right, thank you very much. Thank both counsel for your arguments here this morning. At this time, this matter will be deemed submitted.